All right, let's talk about the duty of care in a little bit more detail. Remember, the duty of care focuses on the decisions of the directors or the executive officers. But the duty of care cause of action, the focus is not on bad decisions. If you go into court claiming a bad decision by the board of directors, the court will just apply the business judgment rule and your case will be thrown out of court. The focus is on the decision-making process. To allege a breach of the duty of care, you have to focus on a flawed decision-making process by the board of directors. All right, let's talk about the standard of liability for breaching the duty of care. As we said in earlier discussions, the board of directors or any director or any executive officer will not be liable for breaching her duty of care unless she engaged in a grossly negligent decision-making process. And usually when we're suing the board of directors, we're suing the entire board of directors for a grossly negligent decision-making process by the board. We're not usually suing individual directors in this cause of action. Some jurisdictions might use the term reckless instead of grossly negligent. In any case, we are looking for something other than just ordinary negligence. It has to be grossly negligent or reckless decision-making process. What are we looking for in terms of facts? Well, we're looking at what the board did. What was the board's decision-making process? And we're focusing on whether they had sufficient quality and quantity of information. And then we're looking at their deliberation. Did they have deliberations of good quality and of good quantity, of timing, right? Naturally, the more material the transaction, the larger the transaction, the more risky it is, the more investment it requires of the corporation, the more information and more deliberation we are requiring of the board of directors when they make their decision, when they go through their decision-making process. Let's talk about the possibility of fairness as a defense in the duty of care context. Remember when we talked about the duty of loyalty context, we said that a director could say, listen, I was conflicted in the transaction, but I should not be held liable for breaching my duty of loyalty because the transaction was, in the end, fair to the corporation. Will a director who is being sued for a breach of the duty of care have the same argument? And Delaware case law indicates that this might be possible. You might be able to escape liability if you can show that despite the board's breach of its duty of care, that the transaction was substantively fair to the corporation and that the process was fair, that it was procedural fairness. Now, the procedural fairness is a little bit difficult to comprehend in a duty of care case. Maybe it's possible, but it seems to me that it'd be difficult to show that there was procedural fairness when I engaged in a reckless decision-making process. But the possibility is out there. What about ratification? Remember, when we had a duty of loyalty claim, a director who engaged in some sort of self-dealing or took a corporate opportunity could escape liability if she showed that the transaction was ratified or sanitized by disinterested and independent directors or shareholders after full disclosure. So in the duty of care context, when we're suing the entire board of directors for a breach of their duty of care, saying they engaged in a reckless decision-making process, can they escape liability by saying, yes, we engaged in a reckless decision-making process, but the transaction was ratified by the shareholders. Shareholders that were disinterested and independent approved the transaction. Once again, there might be some case law out there that indicates that this is possible, but I think that it's still somewhat dubious or difficult because we still have to show that there was full disclosure. So full disclosure of what in this context? Well, we expect the board of directors to fully disclose that they breached their fiduciary duties to the shareholders before the ratification. I think that's unlikely. It seems like a very strange or even impossible context where the board of directors says, listen, we engaged in a reckless decision-making process, and you shareholders, we hope that you will ratify the transaction. Seems possible, right? It seems like that process is out there. It seems like it's unlikely that a board of directors would do this. Usually, the board of directors engages in a reckless decision-making process, and they don't quite grasp that it is reckless, and then sometimes the shareholders will be asked to approve the transaction, and then the directors, after the fact, are arguing that the shareholders ratified the transaction, but they really weren't seeking ratification. We required shareholder approval for some other reason, and I think the flaw in the ratification in this context is that the board did not disclose to the shareholders that they engaged in a reckless decision-making process. All right, let's talk about the exculpation clause and how it applies to the duty of care. Remember, we talked about Delaware law and the Revised Model Business Corporation Act. Both of these laws allow corporations to put in their articles of incorporation a clause exculpating directors for breaches of their fiduciary duty. Now, we've talked about this in the context of the duty of loyalty already, and we said that an exculpation clause cannot exculpate a director for breaches of her duty of loyalty. But it can, and indeed is designed to, exculpate directors for breaches of their duty of care. So if your corporation has this exculpation clause in its articles of incorporation, and virtually all public corporations do have an exculpation clause in their articles of incorporation, then if the directors engage in a reckless decision-making process, which would implicate a breach of their duty of care, they still will not be liable to the corporation because of the exculpation clause. This provides even more protection to the directors and to the directors, not the officers. Remember, the exculpation clause cannot protect the officers. All right, let's talk about the justifications of providing the directors with so much protection under the duty of care. Right? The idea is that business decisions, business transactions, and any course of action that a business will take will involve risk. You can't avoid the risk. A failure in business, a failure of some sort of transaction or a failure of some sort of line of business does not necessarily mean that it was a bad decision to enter into that transaction. And it doesn't necessarily mean that there was a bad decision-making process. Imagine we have a transaction that we're considering entering into, and we think that there's only a 10% chance that we'll lose money in this business. Well, as it turns out, we do lose money in this business. Was it a bad decision to enter into this transaction? No, it wasn't. It was a very good decision if we accept my hypothetical that there was a 90% chance of success of this transaction, right? The 10% came to fruition, and it's unfortunate that it did, but that doesn't mean it was a bad decision to enter into the transaction. Now, naturally, we could give the matter to the courts. We can say, listen, courts, you're fact finders, you determine the facts. Was it a bad decision? But not only will we have the cost of a trial in those situations, we will have the cost that we might get it wrong. We'll hold directors and executive officers liable for business failures when really it was just a matter of risk, right? And it's risk that they should be taking. Now, imagine you're a shareholder. What do you want your directors and executive officers doing? You want them to be able to engage in business risk. If they're not taking risks, then you're not going to make any money. There is no money made in business without taking risk. Now, you want them to take appropriate risk, but we have to admit that we want them taking risks. And if we have a standard of liability that might hold them liable for any type of business risk, right? After we go through trial, and we naturally think that people are just going to equate the failure of a business transaction with a bad decision. If we're going to have that, then our directors and executive officers are going to be very conservative in their decision-making processes. And then as shareholders, we're not going to make the money in our investment that we want. All right, let's talk about the duty to monitor. Now, one of the most common fact patterns that implicates a breach of the duty to monitor is where the board fails to detect or prevent some sort of employee misconduct. Now, you have to remember that the board does not meet to discuss every matter that involves the corporation, right? The board only meets to discuss the large policy issues of the corporation, right? Most decisions on a day-to-day basis are made by the executive officers and the employees. Now, when the executive officers and the employees of the corporation are responsible for making decisions and acting on behalf of the corporation, we are necessarily going to be worried about the executive officers or the employees making poor decisions, or whether they are using their authority to benefit themselves at the expense of the corporation through shirking or stealing. Or maybe the employees are engaged in some sort of illegal activity. Now, if this type of misconduct harms the corporation, the shareholders are going to be upset and they're going to want to sue the board of directors. The cause of action they will use is the failure to monitor the corporation, or a breach of the duty of oversight, the breach of the duty to monitor. There's another type of transaction that will often implicate the duty to monitor or the duty of oversight, and that's where the board fails to consider a transaction or a course of action. So we have a board of directors and they miss some sort of opportunity, or they should have entered into a transaction that would have protected the corporation or benefited the corporation, but they never met to decide it. It would be another thing if they met to decide it, they discussed it and then decided against it. In that case, that's a business judgment rule case and a duty of care case. But if they never meet to discuss this, they never think of it, they never consider it, well, then what cause of action can we use to sue the board of directors? And in that case, we'd use a duty to monitor or a duty of oversight cause of action to sue the board of directors and try to hold them liable for breaching the fiduciary duties. As we see, a duty to monitor claim, a failure to monitor, or a breach of the duty of oversight is a very difficult claim for the shareholders to win. All right, let's talk about information and reporting systems. What is an information and reporting system? Well, most corporations have this, and they should have information and reporting systems. It's a way to gather information from the lower levels of the corporation and make sure it goes up to the board so that the board can be aware of what's going on in the corporation, right? Normally, it involves issues of legal compliance. So if a corporation, we are subject to certain laws and we have to make sure that we follow these laws, right? We're going to have some sort of information and reporting system to make sure that our employees are following the law. And we're also going to have information and reporting systems about job performance of our employees. Are they competent? Are they doing their job well? And then there's the issue of honesty. Are they stealing from the corporation? Are they acting in good faith? An example of information and reporting systems that have to do with honesty or stealing from the corporation are financial audits, right? We audit our business to make sure that our employees are not stealing from the corporation. Let's talk about the standard of liability for the duty to monitor. It is very protective of directors. One Delaware judge has said this: "This is possibly the most difficult theory in corporation law upon which a plaintiff might hope to win judgment." So you might bring a duty to monitor claim, and your fact pattern might fall within the fact pattern that we say, yes, this is a duty to monitor issue, but you will probably lose that claim. Why? Because the law is very protective of directors. Here's the standard of liability. A director or the board of directors or even an executive officer will be liable for breaching the duty to monitor or the duty of oversight only in situations where they failed to act in good faith. So, what type of situations will we have where a director or executive officer fails to exercise her duty to monitor in good faith? Well, number one, where she was intending to harm the corporation. Naturally, this is a fact pattern that we don't see a lot, and even if we did see it, it would be difficult to prove that the director or executive officer was trying to harm the corporation. The other one, probably more common, where the director or officer acted in conscious disregard of a duty to act. She failed to act in conscious disregard of a duty to act, right? This requires her to have a duty to act and also for her to consciously disregard it. All right, let's further develop the idea or the concept of disregarding a duty to act by talking about absent or unqualified directors. One of the subsets of the duty to monitor claims is we have directors who are either absent, they don't attend director meetings, right? They don't attend board meetings, or they're unqualified. They don't understand what they're doing. And so the question then becomes, can we hold this director liable for breaching her duty to monitor because she didn't come to meetings or because she was wholly unqualified? The judges and the courts generally say that a director has a general duty to attend board meetings, keep apprised of corporate activities and affairs, and understand the basics of the corporation's business, right? This is a general duty. I say it would fall under the duty to monitor. Others might say it falls under the duty of care. In any case, I think you understand that there is this general duty. Now the question is, will a director actually be held liable for monetary damages for not attending meetings or for not keeping apprised of corporate activities or for not understanding the basics of the corporation's business? In theory, those are all breaches of the general duty that directors have, but generally directors who fail in any of those aspects are not held liable. Why? Because there's a problem with causation. Did her failure to attend meetings cause the harm to the corporation that we are alleging as shareholders, etc., right? Even if she didn't attend the meetings, there are other directors who were there. They made the decision to enter into the transaction. It's hard to say that if our director, if the defendant director had attended the meetings and had she kept apprised of corporate activities and had she understood the basics of the corporation's business, then she could have prevented the harm from entering into this transaction, right? It's very speculative. So directors are rarely, if ever, held liable for breaching this general duty. Let's talk about the duty to monitor when there are some warning signs out there, where there are some red flags. And the fact patterns usually involve some sort of situation where the board becomes aware of some sort of, and I'm going to use the word potential employee misconduct or some other potential threat to the health of the corporation's operations or business, right? So we do have some sort of warning signs, right? And then the question is, if the board ignores these warning signs or does nothing about it, will they be liable for failing to monitor? Will they be liable for breaching their duty to monitor the business and affairs of the corporation? And usually there are two separate fact patterns where the board does nothing, right? Where there's these warning signs and the board does nothing, or where the board actually meets and discusses this issue and then decides to do nothing, right? You see the difference between these two fact patterns? The first fact pattern is where the board does nothing, doesn't even meet, possibly doesn't even recognize the potential employee misconduct or the potential threat to the corporation. The board does nothing. The second fact pattern is where the board recognizes it, meets, and then decides to do nothing, right? The problem with holding the director liable for the situation where the board does nothing, right? The problem with holding the board liable for breaching their duty to monitor is that there is usually potential misconduct or potential threat. And remember, the standard of liability is conscious disregard of a duty to act. And so when there is potential misconduct or a potential threat, now it's difficult for the plaintiff shareholder to argue that the board acted in conscious disregard of a duty to act when there's potential threats. There's always potential threats. Does the potential threat rise to the level of being so imminent and so large, right, so material that not acting would be a conscious disregard to a duty to act? Very difficult for the shareholder plaintiff to prove. The second fact pattern, where the board meets, discusses, and decides to do nothing, this is just a legitimate business judgment. There are legitimate business reasons why you might see a threat as a board of directors and say, we're going to do nothing about it, or even employee misconduct. Imagine you've caught an employee embezzling and you say, well, we're going to do nothing about it. It might be too costly to deal with this problem. The cost of the misconduct might be less than the cost of dealing with the conduct. Or the cost of the potential threat might be less costly than actually dealing with the problem. Or the board might frankly say, we can't deal with this problem. There are reasons we can't deal with this problem. So if this is a legitimate business judgment, then the court will just apply the business judgment rule. And then you have to rely on a duty of care claim. You have to say, listen, the board engaged in a reckless decision-making process. Let's talk about the duty to monitor when the board does not recognize any warning signs, when there are no warning signs out there of some sort of potential employee misconduct or potential threat to the business of the corporation. When the board fails to detect this threat, when the board fails to detect the employee misconduct, or the board fails to recognize the threat to the corporation's operations or business, will the board be liable for a breach of the duty to monitor? Remember, the standard is a conscious disregard to the duty to act. For this type of fact pattern where the board fails to detect something, it's hard to say that you had a conscious disregard. You didn't detect it, so how could you consciously disregard a duty to act? You didn't know about the threat. Delaware has come up with a specific standard to look at when we're talking about the board's failure to detect employee misconduct or some sort of threat to the business of the corporation. First, Delaware courts have said the board has a duty to establish some sort of information and reporting system. We already talked about what information and reporting systems are, right? And so the board has a duty to set up some sort of information and reporting system. Otherwise, how can you make decisions if you don't have information coming to you? But you will only be liable for breaching your duty to monitor when you have engaged in some sort of sustained or systematic failure to exercise oversight, such as an utter failure to attempt to assure a reasonable information and reporting system exists, right? Once again, it's very difficult for the shareholder plaintiff to show that the board engaged in sustained and systematic failure to oversee the business and the employees. It's very rare that this happens, right? Sometimes the board misses things, and sometimes the board is careless about monitoring the employees or the business of the corporation. But it's rare that a board of directors will engage in sustained or systematic failure to exercise their duty to oversee the corporation. Also, with respect to information and reporting systems, the failure to have an information and reporting system in and of itself is not a breach of the duty to monitor. It has to be an utter failure to attempt to assure some sort of information and reporting system exists, right? And so that's not just one moment in time, it's probably over a long period of time. Once again, take my word for it, it is very difficult for a plaintiff shareholder to succeed in this claim against the board of directors. All right, let's talk about the exculpation clause and how it applies to the duty to monitor. Once again, to refresh your memories, both Delaware law and the Revised Model Business Corporation Act says that a corporation may put in its articles of incorporation a provision that exculpates the directors for breaches of their fiduciary duties. We have seen that this does not apply to breaches of the duty of loyalty. You cannot exculpate directors for breaching their duty of loyalty. It does indeed apply to situations where the board of directors breaches its duty of care. You may protect the board of directors if they engage in a reckless decision-making process. How does it apply to the duty to monitor? Well, remember, the duty to monitor, the standard of liability is that the board failed to act in good faith. Both the Delaware provision and the Revised Model Business Corporation Act provision say you cannot exculpate directors for failure to act in good faith. And therefore, because the duty to monitor liability is based on a failure to act in good faith, if a director or the board of directors is liable for failing to exercise proper oversight because they did so not in good faith, then you may not exculpate them based on your exculpation clause in the Articles of Incorporation.